Boom. We are live. What's going on, people? If you guys don't know who I am and you stumbled upon this channel, my name is Nate the Lawyer. And today we got a bombshell that kind of dropped on us today. And I mean bombshell. So one of the jurors from the Kim Potter trial decided to come forward and explain how they came to their verdict. And right now, unfortunately, after reading it, it seems like they are. I'm just going to say it. Oops, I got an echo. All right. No, I can't have an echo. They are. They convicted her under the wrong legal standard. So let me pull in my friend Uncivil Law. Boom. Uncivil. What's going
What's
on?
up? What's up?
Nothing much. Nothing much. Just trying to figure out what's going on with this juror. So it's unbelievable. It's unbelievable what happened after reading this thing. So have you read this article about the Kim Potter
I
juror
have
who just
not
came out
read the
today?
article. No, I saw Natalie Lorchuk discussing it a little bit, but I've not actually read it myself. So I get to share most of my thoughts fresh with you. Exciting.
So we get so you get to get it fresh with me. So just so everyone understands right off the beginning, the issue that myself and Kurt had with this case, right? The issue that we had, myself, Nick, all the attorneys who've been watching it on Nick Stream, we've all had the same issue with this case, and that is the difference between negligence and recklessness. Now, Kim Potter, to convict Kim Potter of any crimes, the jury had to find that she was reckless in her actions. So this was kind of a reckless homicide. Recklessly, either she was recklessly handling a gun or she recklessly caused the death. Now, the difference between recklessness and negligence is a very, very fine line. But the law explains it to be a conscious act versus an unintentional act. So think about it this way. The classic examples of slip and fall at a supermarket. If someone drops something, then for a negligence claim, the jury would just have to find that the store should have known that the store owner knew that they should have known that the floor was wet, that there was something on the floor. So that's what should have been known. You should have known something was on the floor. The store owner actually didn't have to know something was on the floor that would cause a slip, but should have known. Versus recklessness. Now, you could change that same slip and fall to a reckless act, where if the store owner actually knew that there was oil or something on the floor, and then said, I'll clean it up in an hour, and then someone trips and falls, maybe even die, then you might have an involuntary manslaughter. It'll probably be hard to prosecute, but yeah, you could have an involuntary manslaughter. You recklessly, you were knowledgeable of it. You knew that there was this hazard on the floor, and you disregarded it, and someone got injured. So, Kurt, how do you feel about the difference between the two standards, recklessness and negligence?
Well, I mean, I understand it because I understand everything.
No, I'm saying, how do you feel about it? Did I explain it right, or what do you think?
No, I think you got it right. Yeah, negligence is failure to do an obligation you have, but doesn't imply a conscious disregard. Recklessness implies some sort of conscious disregard. Driving drunk implies that you are doing something with knowledge. Bad things will emerge. You may not necessarily know what those bad things are, but you're doing it with some conscious knowledge of it. And negligence, not so much. How you doing, Alita?
Good. How are you?
Good. We're trying to understand why juries suck.
So
because you know what it is? It's because juries are made up of people,
and people suck.
People are not rational. We like to think of ourselves as rational, but we are very much emotional beings. So cases like this, I think, really highlight
you take that back.
No, you know what? Like you guys are saying, cases like this, it makes it really, the one great thing I do like about this interview, even though when we listen to it, it really shows you the human element of the law, and
Yes.
how just regular people, it really comes down to regular people who are not lawyers, who are interpreting the law and coming to conclusions. And I think this is really a failure in the system, because this is something, because based on when you guys listen to the article, you'll see exactly what I mean. How this juror essentially is saying they convicted her of negligence, and it became criminal negligence. That's essentially what's happening here.
Yeah, that is true.
All right, so let me do this. So since we're talking about Minnesota law, and we know a fantastic Minnesota attorney. His name is what? Nick Recchietta, right? He's a fantastic
I was going to ask
Minnesota attorney.
Are we talking about the same person here?
Yeah. Well, what we're going to do is that he did a video where he explained the difference in Minnesota between negligence and recklessness. And I want to have him explain it because he did such a wonderful job. So we're going to listen to his explanation. Then we're going to listen to the jurors' own words as they explain how they came to the decision, to see why I believe, unfortunately, now this Kim Potter decision is completely unjust. So first, let me pull up Nick's explanation on the difference between negligence, criminal negligence, which is necessary for recklessness, and just regular negligence. Here we go.
All right.
This is manslaughter in the second degree by culpable negligence. It is more than ordinary negligence. It is more than gross negligence. It is gross negligence coupled with the element of recklessness. It is intentional conduct by which the actor may not intend to be harmful, but which an ordinary and reasonably prudent man would recognize as involving a strong probability of injury to others. But remember, it is intentional conduct. You must intend to create this risk. The difference between the terms recklessly and negligently, as thus defined, is one of kind rather than degree. Each actor creates a risk of harm. The reckless actor is aware of the risk and disregards it. The negligent actor is not aware of the risk, but should have been aware of it. Minnesota Statute 609.205 defines second-degree manslaughter in terms of culpable negligence, whereby the actor consciously takes the chance of causing another's death or serious injury. This definition corresponds with recklessness as defined by Wharton. In Bielke, we called this kind of recklessness intentional conduct which the actor may not intend to be harmful, but which an ordinary and reasonably prudent man would recognize as involving a strong probability of injury to others. But remember, the risk of the injury must be conscious.
Boom. They cut us off right with the ad, too. I was stopping it. So now I want to make sure the audience is clear of what Nick is saying. Nick is saying just two things, right? Negligence is you don't have to be conscious of the risk. You don't have to know of the risk. You should have known, but you don't have to know. Versus criminal negligence is you must know. So it's between not knowing and knowing. Would you guys agree with that?
Yeah.
Yep.
So now, and I think Nick did a very good job because he went into the case law. And for those of you who don't, definitely check out that video if you want to get more into it. But if they're convicting her on the standard of she should have known, if they say something like, we don't believe she should have had the gun, we don't believe she was aware she had the gun in her hand. That's negligence, right? If we don't believe she was consciously aware she had the gun in her hand, that's negligence. Versus recklessness, where we believe she was aware she had a gun in her hand and she recklessly and it was discharged recklessly. And some people were asking me earlier about how can you what would be a situation where you can recklessly have a firearm in your hand and it go off? And I said, well, you can drop it, right? I can pick up a gun to point at you and I can drop the gun and the bullet can go off, and then that would be reckless, right? Because I recklessly
You can also
handled
swing it around on your finger, or
something
handle
like
it in
that,
some way that is very irresponsible.
There's no way this gun is loaded. That would be an example.
Yeah. To tie it to another famous case.
I am a police officer. I am ATF. I'm the only one qualified in this room to handle this pistol. Yes, that might be an example.
Patrick says, given the spelling of her name, Should legal bites be pronounced legal?
Legal
How do you
betas?
pronounce that? Betas. Betas.
I think like Alita, because the YTE.
Ah, I like it.
Maybe that's
Should we move
not
to
a bad idea.
Should we move to a system where the jury is lawyers? Well, that isn't that what happens in England, right? The jury is all the lawyers. Do you think this this would have changed the outcome? Yeah, I
Well,
think lawyers.
what if we had professional jurors? They wouldn't necessarily have to be lawyers, but it would be like a profession, be a professional juror.
I don't know that they would be the reasonable man anymore, though.
No, definitely not.
I mean,
true.
it's
That's
trial
true.
by a jury of your peers.
Yeah, but my peer's
So-
stuck.
Well, that's what you get.
I have to live with those people.
That's
I
what
know
you
that.
get, They're assholes. So let's get into this interview with this anonymous juror. So this is the anonymous juror who's given us an interview based on what they feel, and they give us a window behind the curtain about why they came to the decisions they come to. So this is pretty interesting stuff. So here we go. The Potter Juror. I'm assuming you guys can hear this.
I cannot.
I
I can
can't,
hear
no.
nothing. I hear nothing.
Hold on. I
We can
think
make
I'm
our
gonna
own
have to do this
sounds.
again.
Bop, boop, beep, boop, bop, boop, beep, boop.
I mean, I barely want
think I
me
have
to be
to-
judged by you people, let alone the rest of society.
Oh man.
All right, this says tab is on, sound is on. You guys should.
I
be
know this
feeling
has
pretty
always
nice
been
now.
like the bane of my StreamYard
Yeah,
existence.
that's a
is
good
trying
one.
to get
That's-
down on these videos.
That's a good one for you, Legal Bites. You're on trial. Who do you want? A jury of your peers or this asshole? Who do you want?
Depends on if I have
All right.
good facts or not.
Former Brooklyn Central Police
Here we
Officer.
go.
Can you guys hear
One
this?
juror shared
I can.
details of the
Yes.
deliberation.
You guys can hear this one, right?
Yes.
Yes, it sounds like a robot,
right, so
but
here-
I think that's what we're going
This is
for,
this
right?
is this is the robot. Yeah, we're going for a robot.
One juror shared details of the deliberation with Car 11. He asked to remain anonymous because of the amount of public.
I think this. I don't like this voice. Let me pull it. Let me get Sharon. Let me use Sharon.
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 What you got for us,
Let me
babe?
speed her up a little
Sharon.
bit. Let's see what Sharon does for us.
He asked to remain anonymous because of the amount.
Is Sharon better?
Oh, she sounds congested
Sharon's
like
better.
me. Maybe she has COVID.
Oh, man.
He asked to remain anonymous because of the amount of public animosity involved with the case. Car 11 reporter Laura Hughes covered the entire case, was inside the courtroom for 2 days of the trial, and was able to verify the juror's identity. Immediately following closing arguments, the juror believed Potter was guilty on both counts.
So how do you guys feel about that? Right after arguments, they thought the jury thought that this juror thought that she was guilty after both counts, right after the close.
No particular objection.
How do you guys feel about that?
No particular objection. I mean, at least in principle, jurors can sometimes come to quick decisions. I mean, they've obviously sat through the entire case,
Yeah.
heard everything, so
Mhm.
they're in a position to maybe come to some, fairly snap decisions, depending. So no particular objection.
I mean, yeah, because
Immediately following closing.
You cut off
I'm-
Legal Bites.
I'm sorry.
Because there's no requirement that somebody reserve their opinion until after they've discussed it with other jurors, right? Like you can
That's true,
you can come
yes.
to your own conclusion at any point at trial, really.
Yeah. Oh, gotta load it back up again.
Immediately following closing arguments, but said his opinion fluctuated during the course of their discussions as other jurors challenged him to look deeper at the language of the law. Hughes, take me inside the jury room. What happened during deliberations? Juror, we did an initial vote, then we did temperature checks throughout. Initially for both counts we were predominantly guilty. For count 1, it was 7 for guilty and the remainders were either not guilty or didn't know. Then for count 2, 8 said guilty, 2 said not guilty and 2 didn't know. The day that we asked the judge what would happen if we can't reach a decision, we were evenly split on manslaughter, 1 at 4 guilty, 4 not guilty and 4 I have no idea. And at that point we were just arguing semantics and kind of in circles.
I think this is interesting in this part. The fact that he's coaching it as 4 guilty, 4 not guilty, and 4 I don't know. Generally, those I don't know should all be not guilty, right? It should be 4 guilty and 4 not guilty. I don't know is not guilty, but they're coaching in a way as like, like she had to prove she's almost innocent by those 4 not guilty. That's kind of what I'm getting at.
Yeah, that's interesting because it's the default. You're right. The default should be innocent until proven guilty. So if you are undecided, that means that you should be biased towards innocent as opposed to guilty or not guilty.
I'll give him a break. I mean, I think there's a bit of a difference. Well, because it is a presumption, and some people might be able to have their minds brought up fairly quick, and some people haven't heard enough things yet. So, the default. I understand the default, but it's like, am I ready to say I'm ready? If let's just go with the easy scenario. 11 people say not guilty, and you come to me as the 12th person, and I understand this until proven guilty, but I'm just not ready to cast that vote yet because, I still think like maybe I haven't worked through the evidence yet. I just haven't resolved it all in my head as to whether or not I can get past that threshold or not. So I'm like, I'm just not sure yet. I understand there's a default here, but I'm not ready to cast that vote. Is that wrong? Am I making sense?
I'm not saying
my bad lawyer.
You are making sense, but I think that's the problem. I think that's now we're talking about a lawyering issue versus a jury issue. Because if you're the defense attorney, you're supposed to get up there and make that point. If you don't know, that's a not guilty, right? How many times have you screamed that, right? If you don't know, it's a not guilty. This is not guilty and we don't know and not guilty. No, you're supposed to make it very, very clear. So those people who go in there who say, I don't know, and you're supposed to have somebody say, so you're not guilty then, right? Because I don't know. Not guilty.
But isn't there a distinction to be made between saying not guilty because I've considered all the evidence and I've considered all the evidence and there's no path to get to guilt beyond a reasonable doubt, so not guilty, versus I know I have a default presumption of not guilty or a default presumption of innocence, but I haven't worked through all the evidence yet, and I can see a potential path for the prosecution based on the evidence that I've heard. It's like I can see a path, at least in my head, for them to get there. I'm not ready to say that they're there yet because I haven't considered through the path, but I see the potential path. Yeah. So I want to have more discussion first because I'm like, well, I see potential lines that if we discuss them look like they might lead to guilt beyond.
Yeah, that's fair.
Guilt beyond. Yeah. So I'm just not sure yet.
That's
fair.
So
I can see a sophisticated way of making that position.
You could be working through the pieces of evidence also that are directly on that border between overcoming that presumption and not overcoming that presumption.
That's true. Yes, definitely.
So,
let me get the super chat.
Yeah.
I'm so glad I found your channel, Nate. Oh, thank you. Watching your videos of the media's egregious sloppy coverage of the Rittenhouse played a large part of my decision to quit watching the Young Turks.
Whoa.
Oh, thank you.
That's a big compliment.
By the Young Turks.
and also to be fair,
you're poaching their viewers.
And also to be fair, it could be the other way around. Also in that situation, like it could be. I know that, but I feel like I think the paths are to proof beyond a reasonable doubt. So I think it's there, but I still want to hear some arguing because maybe some people can persuade me. So at least in my mind, I've tracked a path and I'm like, oh, I'm there. But I'm not sure yet because maybe I've made some fault in my thinking. I want to check my reasoning.
Yeah, that's fair.
One thing I do want to mention is that this was going in there 4-4-4, if you want to call it 4-4-4. She had a nice shot. Well, the first one, the second degree, it seems like they were 7 to 7-5 because it's 12 jurors. So they were 7-5 on that one. So she actually had a real shot of getting acquitted. But this is where I think the misunderstanding of the law really kind of changes things because she's really actually ahead on the higher charge and the lower charge, she's behind. So it's interesting to see kind of how they try to work their way through it. Let me get back to the piece so we can continue to see how he works, how we'll have the jurors work through it.
This case was interesting because there weren't really facts that were in dispute. It was more our interpretation of our jury instructions and the law.
Ooh, that's never a good thing.
So the jury is going back to say we have to interpret the law.
Yikes. You never want they are finders of fact, not finders of law. So if they're not, that means that it was not clearly explained to them what the law is, because it's not up to the jury to figure out what the law is. They're
Yeah,
supposed to be
we have all the
instructed,
facts.
you
We just
apply
don't know what to
this.
do yet.
Woo, yikes.
Oh my God. Yeah, so we got to kind of figure it out. Hey, we got to figure out the jury. We got to figure out what's going on here.
You know,
But
and
but again,
this is something that is a relatively, I think, a relatively common issue with juries, is the fact that you have lawyers that are living the law and live the law on a daily basis and understand the law. They understand what they're saying, but they don't necessarily understand how to, or maybe they understand how to, but in practice, it's a lot harder to translate that to people in a way that people can understand, that are totally new to it, that don't have like the foundational, language for understanding these nuances. That's the biggest challenge here for lawyers.
Well,
yeah,
that's the jury of our peers.
Yeah, this is a jury of our peers, and we're just getting into this thing. Just imagine, we haven't gotten into the good stuff yet.
Those last couple days were literally just focusing in on the language of the law. Before deliberations began, Judge Regina Chu gave the jury instructions that laid out the elements of each crime. They all had to be proven beyond a reasonable doubt to reach a guilty verdict. The jurors said the 12-person panel spent several hours in large group discussions as well as smaller breakout groups trying to determine the meaning of legal phrases in the instructions.
Damn.
Oh no.
So they didn't know what was going on.
Oh my God. This was like, oh God.
Yeah, doesn't that mean
I don't know. Is
the
that more about the
I feel
judge
for
or more
them.
about the lawyers? Because the jury instructions, they have to be agreed upon by both parties, right? So the lawyers are the ones that are ultimately like negotiating. They're working back and forth to figure out like what these jury instructions are going to say. So I feel like there's I mean, for me personally, the way that I see it, and correct me if you guys see this differently, but I think that a lot of this falls on the lawyers here for making sure that these jury instructions are actually legible and understandable by the jury.
Yeah, they obviously didn't. It was so confusing to them that it seems like they spent a lot of their time trying to figure out what the law was. What do these words mean, right, in this context? Yeah. And you don't want a jury going back, and literally this jury went back to interpreting law.
Yeah,
and that is a big issue.
Because I mean, here's the thing too, is that if you're the defense attorney here, or the prosecutor for that matter, if you're either attorney on this, and going into closing argument that the jury is about to go into these very heavy jury instructions, and you want them to have, if anything else is murky, but they want to just have one thing be clear. If I were the defense attorney here, I would have made sure in my closing to have had super clear in there exactly how to distinguish between recklessness and negligence, and to say like this is what the law says. It is super clear cut. There's no other way to go about this. No matter like if you take anything else away from this closing argument, that is what you should understand. So I mean, like the attorneys also have the ability to kind of foresee those issues and to know what their case is going to be hanging on.
But now we know we're going into jury deliberation. The jurors like, we had to interpret the law because what they gave us was bullshit.
They had to break up into smaller groups so that they could work their way through. Oh God.
Maybe it's not for nothing. Maybe it's not for nothing that they do call us Juris Doctor. I'd like to remind everyone the word doctor does literally translate to teacher. And so we are supposed to be teachers of law.
Yeah.
So if we're not being good teachers to the jury, then maybe we suck at our job.
This one, Dapper Dave says, Nate, one thing I don't get from you guys, why are you guys so against directed verdicts by a judge? I'm not against directed verdicts by a judge. Why trust average people with no understanding? Oh, this person's talking about judge trials versus jury trials.
Yeah.
I'm not averse to a judge trial.
Well,
no.
I mean, typically, I'm not averse to them in principle. Typically, the factor for the defense is if you convince one, you win. And, you can always bullshit a juror more than you can bullshit the judge. So if you can razzle dazzle them, to quote the Showing from Chicago, you're there. Yeah.
If you were in New York this would have been a judge trial. Why? Because
Oh.
this is the type of trial that I would say I would want to have a judge decide this, because this is more the facts aren't really in dispute. It's really the law that's in dispute. So I would say yes, I would like a judge trial. Here you can get a judge trial for something like this. So and most cops do when something like this happens. Here, because juries, you don't want them fighting with the law. I don't really know what's going on. This, and you get something like this. Now you're convicted. You're like, oh my God, right? So
yeah. Oof. Yeah. And
Patrick's.
And if they are asking about like directed verdicts specifically, I don't think any of us are particularly against a judge, going with it with a directed verdict at the end of trial before it goes to a jury. I mean, a lot of us were thinking that should have been the case in the Rittenhouse trial, as an example. It's just the likelihood, because most judges, they would prefer that the jury make that decision, because then it's less likely for that decision to get overturned.
Well, there's also like first principles to it.
Yeah.
I mean, we're entitled to a jury of your peers. I think I'm correct on this. I believe in early American history, it was completely unwaivable, because it was seen as a guarantee of the Constitution no one could waive. It's like, even if you wanted to have a bench trial, it was nothing. I think the Supreme Court didn't allow for judge trials in the U.S. system from a U.S. I think there was a Supreme Court decision on that didn't allow it for first. If memory serves correctly in my U.S. legal history. Nate's looking skeptical at me as I'm making things up about U.S. history.
You're probably right. It could be no. It could be.
Nate's looking at me, and I'm like,
I don't know.
Maybe I'm making some bullshit up over here.
No, I make mental notes to research stuff that I find to be interesting, and I'm like, oh, that's interesting. I'm going to check that out.
Yeah,
the law should be.
The jury, I think there's a lot of reasons. I think there's reasons for the judge not getting their head too far up their own ass, from our own experience in England and Star Chambers and all the rest of it. And there's probably a lot of very good first principle reasons to let the jury have a decision, especially like before a JNOV. Like you let the jury handle it. I think there's a lot of good reasons where. Yeah, those decisions are probably right by the judge. It's fine.
JNOV is judgment notwithstanding verdict.
Yeah,
here we go.
That's after the jury comes back.
Yeah.
What is it in Latin? What is it in Latin, Nate?
Oh, I don't even. Now you're
non-observant.
But this one, this is true. Patrick is right. The law should be easy for all, but it just happens to be that way. That's why they pay us the big bucks, right? So we can go to.
I don't know that's possible.
Try to understand it.
I actually have thought about this before. Okay, go ahead. I'm sorry.
That's when I run through these super chats before they pile up on me. Can what the jury says after the fact we brought up an appeal? No, we're going to go over that. That's rule 606, I think it is, in the Federal Rules of Evidence. There's some exceptions, but I don't think this falls in one of the exceptions. Surely defense lawyers are loving this for appeal. No. They would be if they could use it, but I think it's one of those we know it, but can we use it? Can juror statements be be used for the basis of appeal? All right, so we got a lot of questions on that. So you know what? I'm going to. All right, so let me just pull it up. Now you guys are going to make me pull up the rule. Hold on, let me pull up the rule.
Let's do it.
The defense should have said, if you believe she thought she had a taser, it was therefore not reckless, and you must acquit. Make it clear.
Got to work on the rhyming scheme.
They did not. Yeah. Didn't lawyers object to the jury instructions, but the judge overruled it? Possibly. Sure, and if they did, that is a great basis for appeal. So you guys are now making me change this crazy StreamYard thing to rule 606. I hope you people love this, because it's pissing me off that I had to go now look this up. All right. So this is juror's competence as witness. This is what you're going to need if you want to use the juror. So it says, at trial, but this is, I think it's B. Yes, it's B, I think. All right, so this is prohibited testimony and other evidence, right? Now, this is during an inquiry into the validity of a verdict or indictment. That's what we have here. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statements made or incidents that occurred during jury deliberations that the effect of anything on the jurors or other jurors' vote or jurors' mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statements on these matters, except for 3 exceptions. A, extraneous prejudicial information that was improperly brought to the juror's attention, just like some evidence that's out that they're not supposed to make the decision on. Like they may have read something.
We
Say,
consulted
look
the
at this
Ouija
news article or
board.
something. Yeah.
Or let's say in Rittenhouse, like you could say that they found out about Jojo Rosenbaum's history with kids. You know,
What was
Correct.
that history? I forgot. Could you remind me?
we all know. We all know. Little
yes,
Jojo.
The an outside influence was improperly brought to bear on the jurors.
Threats, bribes.
Yes, a mistake was made in entering a verdict on the verdict form. That means we meant to say guilty. I mean, not guilty, and we wrote guilty. Like those are the only exceptions that you can bring to bear. So all this is great to know that they convicted the poor woman on the wrong standard, but unfortunately, it helps her not. And I think that this is probably the miscarriage of justice, right? Because it's kind of like, you know, that we know. Well, we will know after we finish reading through it that they convicted her on the wrong standard, but she's still going to spend time anyway. So, if this was the law in dispute,
it's not like they can't make that argument; they just can't make it from what she's saying. What she's saying, what the juror's saying is, what the juror's saying is not on the record. It doesn't exist. It doesn't go to bribes or threats or coercion or Yeah, so no.
It's not even like, they happened to watch TV and they saw that their local representative, member of Congress, was talking about, how much they needed to come out with a guilty verdict or something like that.
Clearly, they weren't watching a Nick Rekieta stream. Damn.
If it was a law in dispute, why a jury at all? Well, again, the jury determines what the facts are. The judge determines the law, so that's why. So the jury. So even because all the facts weren't in dispute, you still have to have a jury determine these are the facts, and then they determine whether the person is guilty or not guilty. Excuse me, Alita. It's just passing from California.
No!
You got me from California.
Virtually passing the coof.
No. All right. So hold on. So
it's everywhere though. It's literally
it's
everywhere.
Crazy.
I tried to avoid it. I went, Mr. Bites and I, we spent Christmas on Catalina specifically to avoid family with COVID. And then turns out my trip got extended.
The juror said the 12-person panel spent.
What's that?
So you want me to come visit
the juror said the 12.
Well, I'm no longer on Catalina.
The juror said
in quarantine with my parents. Sorry. We'll continue.
No, it's fine.
The juror said the 12-person panel spent several hours in large group discussions as well as smaller breakout groups trying to determine the meaning of legal phrases in the instructions, such as conscious or intentional act. Ultimately, the juror said they decided Potter didn't necessarily need to be aware that she's holding a firearm or using one to be committing reckless handling of a firearm, because the jury instruction goes on to say in connection with the handling or use of a firearm. And they determined there were intentional acts involved even though none of the jurors believe Potter meant to shoot right with her gun.
Well, hold on. This makes no sense. How can you be conscious of something, right? If it's you're conscious of the act and then not be intentional. I'm thinking that they're conflating the two, right? Because did she intentionally pull the gun? Yeah, but it's a conscious disregard of the risk. So they're conflating the two of her actually drawing the weapon and being conscious that she has a weapon or she's creating the risk. Am I making sense, or am I conflating this too much?
I think that we had a discussion about this. I can't remember exactly what it was in the context of, but I remember, Nate, you were clarifying this for me when we were talking about it. The difference between having like the conscious ability to do something and then consciously deciding to do something, if that makes any sense. In terms of like a culpable mental state.
Yeah, well, from what I've always understood, right? To be conscious, to have a conscious disregard means I did something to create the risk, and I did that consciously, right? I meant to do that thing, so I meant to pull the gun, right? And that created the risk. I meant to step on the gas pedal to go through the red light. That's consciously creating the risk. But unconsciously, and that's the difference between mistake and non-mistake, right? Mistake is I'm unconsciously doing something versus consciously doing something. It's not a mistake. I know that I have a gun, but I'm disregarding that risk. You can't disregard a risk that you're unconscious of. Does that make sense?
Yeah. Yeah.
Is it
No,
possible to
I think
disregard a
so.
risk that you're unconscious of? And so that's what
No.
they're saying. They're saying we know she wasn't conscious of the fact she had a gun in her hand.
Yeah.
So then how could it be reckless? If you don't know you have a gun in your hand, how could it be reckless? To handle a gun. Because think about this. If that's true, if what this juror is saying is true in this case, Alec Baldwin should easily be found guilty.
Well, if we're going to compare
Because
this case
he
to other
knew.
cases, man.
Well, but I'm saying, but think about this. Alec Baldwin knew he had the gun in his hand. She did.
Yeah.
Yeah. Yeah.
So he's dead.
Yeah.
So by
He talks
default,
about pulling
he's
the
guilty. He
hammer
knew.
and everything.
Yeah. And he absolutely knew he had the gun in his hand, which she didn't. So he doesn't even have that as defense.
If we're going to compare this to anything, I was talking to this earlier on Nick's chat about the shooting of Danielle Shaver, the white kid in the hotel who was asked to do the hokey pokey and turn himself around before he got shot by the cop with the AR. And that cop was found not guilty for some reason. It's like, how do you square the shooting of Dante Wright and the squaring of Danielle Shaver and those two verdicts in the same universe? Have you seen that video, Legal Bites, with the Danielle Shaver one?
Daniel? No, I don't think so.
It's depressing, man. It is a depressing video. This kid is on this kid's on hands and knees in a hotel. Shit, help me out. Well, not the lobby, but help me. Hallway. Thank you. Damn. Hotel hallway. And this cop is giving me all kinds of contradictory commands. He's like, crawl forward, don't use your hands, put your hands there, put your hands there. And he can't like comply with it all. And like his pants keep falling down and all the rest of it. And he's like, if you reach for your pants one more time, and he reaches for his pants one more time, it just blows him away. It's a really depressing video to watch.
Oh God.
If you want to ruin your day.
Oh God.
And that cop was found not guilty.
That's pretty surprising.
Yeah. Oh, and it was even worse than that because the cop's AR on the ejection port said something like, "Oh, I was just looking it up. It said you're fucked." It was engraved. It was engraved with "you're fucked" on the ejection port, and still found not guilty. So yeah, that was fun times. And the DOJ didn't bring charges in that case for some reason. I think that was South Carolina. No, it was Arizona. I remember. It was Arizona. That's right.
Make sure I got it. All right. So let's get back to this juror's madness right now, because this is going to get depressing.
And they determined there were intentional acts involved, even though none of the jurors believe Potter meant to shoot Wright with her gun. Raguse, which witnesses swayed you the most? Juror: I know some of the jurors didn't really respond well to Professor Seth Stoughton.
That was the prosecution's witness, the professor.
Yeah.
But I really liked him, and I know some other jurors did too.
Okay.
I feel like he was the only expert witness.
Go ahead, Kurt.
No, I was like, what bullshit is she about to say when she just said, I feel like he was the only expert witness? What's the rest of that sentence?
I feel like he was the only expert witness who really had an assertion that was relevant whether use of force was justified or not.
Really?
He actually looked at the totality of the circumstances and also through the lens of what a reasonable officer would do, whereas some of these other expert witnesses did not do that.
Well, fuck me, dude.
Yeah.
I guess is all I have to say to that. Jesus Christ. We all thought this other expert was a joke, and we liked Chat Expert. Apparently, though, they liked Goofy Expert, who's worked a desk for 5 years.
No, but he says some of the jurors didn't like him now, so it was a mix. It was a mixed bag.
No, they liked him. This juror liked him. They thought I worked as a cop and I've been an academic was all the rage. And Chad guy who's been a cop for 40 years and trained. I think when you ask what SWAT teams did you train, the answer is just yes. Apparently that guy was not very persuasive. So fuck me for knowing what's persuasive. Holy God. Let me.
He actually looked at the totality of the circumstances, and also through the lens of what a reasonable officer would do, whereas some of these other expert witnesses did not do that. We also really liked Drive Lawrence Miller. He seemed very knowledgeable
Drive
to us.
Lawrence Miller.
But there were some
Yeah.
conversations about his testimony, because he kept referring to an interview he had with Kim Potter that we didn't have in evidence. And there was a conflict between that interview and Potter's own testimony.
Interesting.
We wanted to know when Potter had this conversation with Dr. Miller, not suggesting Kim Potter was lying or embellishing her story. But their stories just didn't line up, the things she told him and the things she told us.
That's damning, though. It shows you that hurt her. The fact that they
Yeah.
had her speak to this person, the fact that she testified and it was some conflicting things. Like,
Yeah.
which is right, which is
Inconsistent
wrong,
statements.
you know?
Jurors love nothing more than words that come from the defendant's own mouth. It's their
Yeah.
favorite thing in the world. Don't talk to the police, kids.
Ah,
So
this is-
true.
This is the reason why. Here we go.
But their stories just didn't line up. During the trial, Potter's interview with Dr. Miller was only allowed to be used by the prosecution to impeach Potter during cross-examination. The jury was able to glean that Potter never told Drive Miller she saw a look of fear on her partner's face, and at one point said she saw a gun in her hand. The jurors said they felt Potter hurt her credibility on the witness stand when she contradicted those 2 points.
Interesting, huh?
Yeah.
They felt that Potter hurt her credibility when she contradicted those 2 points.
Juror, I don't think any juror felt Kim Potter was a liar, but we did get the feeling she was fighting for her life by testifying, and we understood why she would be. I was very surprised after the verdict came out to learn some people did not find her crime to be real. Just being in the courtroom, it felt very real and tangible to me.
So you see, so it's so
Interesting.
funny how different people find different things to be like, you know, because I was out here, everybody's like, she's faking, it's a fake cry. And in the courtroom, the jurors are like, oh my God, it's so emotional, you know, we really feel
Yeah. I mean, and yeah, there's something about being there physically in the courtroom that can make a huge difference. Like I remember Natalie Wisco was telling me about how when Kyle Rittenhouse was on the stand and he was crying, how she just said that like other than him talking and Binger, cross-examining him or Mark Richards doing his direct testimony, other than those questions and those answers, all that she could hear in that room was the shutter on the cameras, because it was just there was no one that was making any noise in that courtroom. So you get a very different feel, a very different vibe when you're actually physically there in person.
Yeah. It's weird to see because again, it's funny how we all kind of see things so differently, and so many people still to today probably think that it was fake, and the jurors all didn't believe her, but this juror saying no, he thought it was real. It was real to him, and that's the opinion that matters.
Yeah. And that also the point about that everybody understood that she was fighting for her life, that also should be remembered by everyone too, that in any kind of a case, the defendant is always going to be regarded that way by the jury. They're always going to have that kind of starting off at the back of their mind. Like there's a possibility that they might try to bend things in their interest because they have every reason to do so. So
You'd be a fool to ignore it.
Yeah.
You have to keep it in mind.
Of course.
Let's go on.
Just being in the courtroom, it felt very real and tangible to me. She seemed very upset and apologetic. I don't want to speak for all the jurors, but I think we believed she was a good person and even believed that she was a good cop. No one felt she was intentional in this. It's ludicrous that some people are assuming we thought she was a racist. That never even came up or anything like that. We felt like she was a good person. We felt she made a mistake, and that a mistake does not absolve you from the fact she did commit a crime. Being a good person doesn't mean you're a
Kind of does. Kind of does actually.
That's exactly what it does. No, exactly. If you committed a mistake, it totally absolves you of doing a crime.
Yeah.
But
It does.
but it shows you, wow. So this juror really, it's admitting that they committed her. They've convicted her of really committing a mistake, an honest mistake. They've committed.
That is what it sounds like.
Wow. Stupid jurors. Wow.
I think maybe
Being-
not stupid jurors, but confused jurors that aren't fully either aren't fully understanding what their role is in the process, or have not been given clear enough information as to what it is that they're supposed to do and what it is that they're supposed to apply, and how to do it. So yeah.
Yeah.
Minneapolis, editor's note, I don't want to speak for all the jurors, but I think that never even came up or we felt like she was a good person. We felt she made a mistake. Ragus, is it fair to say that if it was
I'm all over the
being
place
a
here.
good person?
I'm trying to find the place where we're at. You can get a place. I don't think anyone felt that she wanted to kill anybody. All right, so there's where we're at.
Being a good person doesn't.
There it
We
is.
felt like she was a good person. We felt she made a mistake. And that a mistake does not absolve you from the fact she did commit a crime.
It does. Yeah.
Being a good person doesn't mean you're above the law. I don't think anyone felt she wanted to kill anybody that day. There was no good feeling. This was just a tragedy all the way around. Ragus, is it fair to say that if it was a rookie officer who did this, it might have been different?
Question.
Juror, this.
What do you guys think about that question? Do you think
I think
this
that's a
was
good- I think that's an interesting question here, because that may highlight an interesting nuance for the jury here. I have a feeling, and I haven't read this article yet, but I have a feeling that they're going to say, yeah, we talked about it, and yeah, it would have made a difference.
But you know what? It's funny. Let me show you guys this. This is something I was doing in my research and I found. Here's a cop who the same exact thing happened. Taser confusion between taser, and he was convicted, and he was only on the job for 1 year. His name is Robert Batts.
No, I think it's one of those things you can never be
That's
right.
something we
I think jurors think it
kinda
would make
know
a
about.
difference, but it really wouldn't.
All right, so
It's one of the
that's a
things
little bit of
I'm
problem.
sorry.
Second of all, is why is a unprofessional?
Go ahead. Sorry.
No, I was just
Go, but
saying
you're
it's one of
saying.
those things jurors think will make a difference, but no matter what you do, you can't be right. It's one of those things. Oh, you use hollow point bullets because you want people to die. It's because you use non-hollow point bullets you want people to die. You have lots of training experience. Oh, well, look how you should have known better. Oh, you didn't have any training experience. Well, look how reckless you are for not having the training experience. There's no right answer to this. You will be screwed no matter what you do.
Listen, I got nothing wrong, nothing against auxiliary police officers. They're great people.
They're helpful.
All right, very helpful, and they give their time. But the problem is you can't have a man like this on an undercover sting operation. All right, you got to have professionals that do this all the time.
The same way, just with all your years here on the force in New York. He says, no, they're overcharging in the second-degree manslaughter. They say it should be an excusable homicide. They say mistakes happen. You hear him say on the videotape, I'm sorry, it's a mistake. Your thought?
Well, my immediate thought is this is exactly why you need an independent body that investigates the police instead of the police investigating the police. But also another thing that's going to be huge in this case is the potential civil liability of Tulsa, because here you have what is clear a policy and a pattern and practice where a man with training, without training, who was a police officer maybe 50 years ago for a year, maybe not, who is sitting in on a sting operation under the supervision and authority of the state. And he acted in that capacity and deprived this guy of his rights by killing him.
But excusable homicide. When I read that tonight, it sounds like an oxymoron. I realize it is part of the law. I mean,
So
Yes,
now again,
like
people-
justifiable homicide. Yes, these are two options: justification and excuse. These are two legal theories we know well, right?
Now I want people to understand. The argument for Kim Porter is that she was a cop for 26 years. She should have known, convicted, right? But if she was only a cop for a year, like this guy was, it'd be different. But guess what? his ass was convicted too. So it seems like no matter what happens, if you're a cop for a day or if you're a cop for 20 years, if you pull the wrong weapon out of your holster and shoot somebody, you're going to jail. And they're going to use the exact opposites they use for these two different cops, which is crazy.
I don't know why anyone would want to be a cop these days.
Especially in some places. I'll tell you what, man.
God love them. But I don't know, man. It wouldn't be for me. That's for sure.
Juror,
Here
this
it is.
Ragus, is it fair to say that if it was a rookie officer who did this, it might have been different? Juror, this was a discussion we had, and I don't know if every jury member agrees with that, but yeah, that was definitely a sentiment that was expressed a good amount, actually. That really did make a difference. That also played a role in the lens we looked at this through. Because of her years of experience, we weren't really looking at this through a lens of what would a reasonable person do, but rather, what would a reasonable officer do? That was something some of us struggled with because we were thinking of ourselves in that situation, like, I could make that mistake. And then it's like, well, you're not a 26-year veteran.
Damn.
I don't think there's that much daylight between those two things in my mind.
I called it.
You called it. So damn. So, but think about how twisted this really is, right? 26 years of experience, a perfect record as an officer, right? You don't make mistakes. Matter of fact, she went to every training. She was never late. She signed all the paperwork, did everything she's supposed to do. And that's the way they were convicted. Like, well, she was too perfect. She was too perfect, right? You only got 26 years. And then you go to Oklahoma, and the guy who's only got less than 8 years of experience, guess what? He was too new. It's like you can't win with this thing. You obviously can't win.
Or maybe the juries should have been flipped in those two cases.
That's true, right? You put the one juror where. This is, to be fair, Earl Grey did an excellent job on closing on what the law states. Unfortunately, he lost on several motions on the jury.
I thought the closing left things to be desired. It was not the strong point of his case.
I you know what? I think old school works, but it didn't work in the closing. It just didn't work in the closing. You got to be more clear. And I think a lot of times they had too many theories of the case up there. They didn't really stitch everything together, I felt. But I did think they had I would have been still not guilty, but I still felt that there was a lot they left on the table. There's a huge black pill. She was a good person, made a mistake, no intent. This is gross. This is injustice. Of course, yeah. That's the reason why you think we're reading through it. Yeah, this is not justice.
This is reality.
But this is our system. Yeah, this is our system. So whose fault for the misinformed jury? Everyone? Yes. Everyone.
I mean,
everyone.
Yeah, basically.
Officers get a lot of training. They are severely undertrained, and training is the first thing. Yes, the first thing that goes with budget cuts. And one thing too, people don't realize this about Alec Baldwin. Alec Baldwin actually had more gun training than Kim Potter.
I believe
she was getting one a year for 26 years. Alec was getting once every time he did a movie that he had to hold a gun on. Yeah. So he was getting training on all those movies, and he was talking about over a 40-year career. So when people say, well, one gun training is different than another, that's it. Now yeah. So Alec Baldwin is in the worst position than Kim Potter was, because that's the same thing these prosecutors can go in and say, look, he's got 30 years, 40 years of experience, and look at all this training he takes. He takes it on every movie. I have a clean driving record in Illinois. If I accidentally run someone over while speeding, that's the kicker. The while speeding part. See, so you're consciously disregarding the speed limit by speeding, and they die as a class 3 felony. Yes, she got her just desserts, but she wasn't speeding. See, now the way we would change this so she wouldn't be guilty is if we say you had pedal confusion.
Right.
You hit the brake. You hit the gas instead of hitting the brake, and that's what made you speed.
Yeah, the speeding is the reckless conduct, because you're engaging.
That's a little bit more of an analogous situation.
Yeah.
So if you hit the gas instead of the brake when you're supposed to, then that's where you get the problem. So this is thank you. Yeah, we're trying to read it up. And thank you, Hontus. Thank you for your super chat. Hauntress always pushes my me to mentally be challenged. That's why that's why I love her.
That's
No,
good.
it's good to
That's
have
good.
all those viewpoints. Yeah,
Yeah,
she
because
really has some
it
very
mean
good comments.
Oh.
the content always benefits from it.
Oh, yeah.
Also, I was just texted that his Alec Baldwin's dad was a competitive shooting coach as well. So there's also that.
Well, that's interesting. Interesting,
Alec
because
Baldwin-
he's and he himself is like so anti-gun. I wonder what his relationship with his father was like. Interesting. I want to go into his psychology. Does he have dad issues?
If he's
Let's talk about it.
if he's going to
Big
start making
Alec
even more
Baldwin.
anti-gun ads, I know how bad guns are because I killed one. I killed my friend with a gun. I killed with this gun. Let me point at the camera and show you.
And he's like, I didn't even pull a trigger.
That was something some of us struggled with because we were thinking of ourselves in that situation. Like, related, Potter fallout. Attorneys predict more aggressive prosecution of police following verdict. A big turning point in deliberations came when the jurors themselves handled Potter's gun and her taser and felt the differences. The gun was about twice as heavy, and the two weapons had several differences in how they are unholstered and fired. The taser kind of feels like a mouse click, whereas the trigger has some trigger draw weight. That was a key turning point.
Now, for me,
You're telling me you can notice that at the time under pressure? Sure you can.
But that's a failing of the defense, though. That juror being able to say that shows the defense failed. It failed in letting people understand the position that Potter was in. Potter wasn't in a position where she's in the jury room feeling two guns and like, hey, this one's heavy, and this one, look at the trigger. She's in a position of hell. Like, oh my God, this guy's, I'm grabbing anything. And, if you just ran and you got somebody, grab, and I throw one in your hand, do you know it's a gun or a taser? That's the situation she's in. But, the juror, they went to that jury room thinking that, she's holding one and you closed their eyes and said, okay, this is the gun, this is a taser, and pulled the wrong one. And that's not what happened. And this is always the thing about because, and this is the sad part about our system. Sometimes the lawyers not illustrating key points can get you convicted. And this is one of those cases where I think the facts were on Kim Potter's side. I just think they got out-lawyered. I think that's essentially what happened here. They got out-lawyered. And the judge wasn't really helpful to their side either. Let me go here.
Yeah. It's unfortunate because I liked Mr. T.
That was a key turning point.
Yeah, I did too.
Sorry.
That was a key turning point. The juror said.
No, there's like a little delay when I press it. It's like got to load up a little bit. Sorry.
That was a key turning point, the juror said. The juror said when they reached the final day and a half of deliberations, they had already decided beyond a reasonable doubt that Potter was guilty of second-degree manslaughter. But two jurors, a middle-aged man and woman, were holding out on the higher count. Aside from the language of the law tripping them up, they shared concern over the consequences Potter would face if she was guilty. Ragus, what did they say when?
Good. You were about to say something?
No, I think it's interesting. I wonder what were those consequences that they were concerned about, that like, a cop going to jail or what exactly? That's
but objection, no. They're not even supposed to be thinking about consequences.
I know. Right?
That's not even supposed to be a consideration.
Yeah.
So that's the killer. If there are any reasons Andy didn't tell Barney carry a loaded gun, Potter shouldn't have been a patrol cop.
We are not going to Maryberry for any teaching tools here, guys. I'm sorry. No.
You know what? I do know cops, both men and women, who are administrative cops. Those are the people who do all the paperwork. Those are the people who set up the systems and those type of things, and who are not in the street, but then they go on the street for, let's say a parade detail or something like that, or maybe train another officer. And sometimes things get hot and they're just not used to that everyday grind. So, and it seemed like that's what she was doing. She was one of those outreach cops, which doesn't mean she was a bad, not all cops are, what do they call like Dirty Harry, right? Not all cops do that. There's a lot of other people that people do. Yeah,
This also kind of makes me want to watch The Other Guys again. You've seen that, right?
I like The Other Guys. Joe Wells says, former Leo here. This was not. This is not info discussion on CSI, critical stress incidents. That's true, and the stress adrenaline has on your senses. Many studies on this were done on this. Regular people don't live in reality on this.
Yeah.
Love you guys. That is so
Yeah,
true because
I
you're
believe
right.
that for
I think
sure.
because and obviously that's one. But again, I think John is right. But I think the defense didn't stress this enough because again, these jurors seem very comfortable just picking up both the weapons and like, look at this versus this, not understanding you got to add the stress of the situation to that decision to say, okay, now you got to pick it up under all this stress and pick the right one, and close your eyes too, because remember, she didn't look, she's just picking one up, and now
And get it right every time for the next 25 years,
And that's also the other part of that too, is that, I was kind of thinking about this when the juror mentioned in the article that that they were thinking about this isn't just, us as reasonable people, like putting ourselves in the shoes of the cop. This is supposed to be a reasonable officer that we're thinking of. And what's difficult about that is that these people don't have 26 years of experience as a cop. And so there are so many nuances that come with actual experience on the job that would have been helpful for them to understand in a much more visceral way the kind of circumstances that she was under.
Yeah.
But that's also why you have testimony at trial that's supposed to highlight those details for the jurors so that they can learn about that kind of stuff, learn about the stressors that a cop is under in this kind of a situation, learn about the ways in which that impacts their brain function because they're working strictly off of adrenaline, for example. So it's just that kind of testimony becomes very, very important to highlight those sort of nuances that they wouldn't otherwise have any real reason to take for granted.
Yeah. You would notice the differences. Needed to pull a trigger only after pulling the trigger. No, that's true. Because she noticed right after she pulled the trigger. She's like, "Oh my god, this is definitely the wrong tool."
Ruguse, what did they say when they finally changed their minds? Juror, one of them asked me, "Hey, could I just go have a one-on-one with this other holdout? And let's just talk it through and work through both of our reasons together and see if we can come to some sort of understanding." He was caught up on the language and she was not. She helped clear up the language for him.
I thought you were saying something. Sorry.
She helped clear up the language for him. She was caught up on the accountability side of things, and he helped clear that up for her. It was kind of interesting that they worked each other out. In the large group discussions, he kept saying, "I don't think she was consciously aware that she was holding a firearm." We were like, "We get that. We understand. We agree. But you are missing the language where it says or intentional."
So they literally said they don't believe that she was consciously aware.
Yeah.
If they don't believe she was consciously aware, she can't be guilty. If the jury has admitted, she said, "I don't think she was consciously aware." Yes, we agree. What do you got? That's exactly what recklessness is. Being consciously aware.
Yeah. This jury would have been correct in a civil trial for negligence.
Yeah.
This would have been the correct verdict in a civil trial, but not where it regards recklessness, where you do have to have the knowledge that you are creating a certain risk.
This is crazy.
Yeah, it's pretty wild.
So essentially this juror has admitted with that statement that they convicted her of negligence, of just pure negligence, and interpreted it to be recklessness, and gave her the higher count. This was on the higher count. Remember, he's talking about trying to convict her on the higher count.
Yeah. And to clarify for some people in the chat, when we're talking about consciousness, not consciousness, we're not talking about whether she was like actually asleep or not, because I think some people are maybe a little bit confused in the chat. But you can be conscious of the fact that you are pulling something from your belt, right? She was obviously, I think everyone would agree that she was conscious of the act of pulling something, right? But she wasn't conscious of the fact that what she was pulling was a gun. So that is a pretty big difference here, that at least that we see, but the jury apparently did not find that was any real material issue. So,
Well, but
just to clarify that.
they admit, because a lot of people just don't understand. Well, when we mean conscious, we mean aware. Was she aware she had a gun in her hand? Because that's the standard. You have to be aware that you're creating the risk. So there's a super chat that just came up. It says pulling the trigger was conscious and intentional. No doubt about it, right? But the risk profile of pulling the trigger on a taser, if you think you have a taser, versus the risk profile of putting a trigger on a gun is different. Even though a taser can kill you, that's why they call it less than lethal. And a gun, so the amount of risk associated with pulling the trigger on a gun, if I'm consciously aware I'm pulling a trigger on a gun, reckless, right? If I'm consciously aware I'm pulling a trigger on a taser, you don't got anything. So that's where the conviction messes up, because the state would have to prove she was consciously aware that she was pulling the trigger on a gun. That was the risk. But it was actually a gun. Am I wrong, Kurt? Talk to me.
Yeah, she has to be consciously aware that she's engaging in a risk. So that there's something that she's doing that she knows is creating that risk. So I might phrase it slightly different, but if she's not aware that she's doing something, whether it's speeding, like you're speeding, or you're going fast, or you're driving drunk, or you're doing something where you have some knowledge of you're disregarding a danger with some conscious awareness, then you're there. And if you don't know, you're not there. So yeah.
Like an example of that would be if on that day she decided to switch her gun and her taser. That could potentially be recklessness, because she has for her entire history had one on one side and the other one on the other side. But on that day, she decided, why not? Let's spice things up.
Keep them both sides, paint them the same.
Then
put a little LED screen on the Glock so they look real similar. That'd be good.
Yeah.
No, I even say it could even be simpler than that. The department policy says you should wear your taser on your left side, when you're non-dominant side, but I'm saying left side, and your gun on your right side. And let's say she put her taser on her gun side with the gun. Then obviously you can then have recklessness there too. Well, you took a risk by doing that, because the reason why we have it on the other side. But again, this juror is admitting that he's doing two things. He's admitting that this wasn't reckless, but not knowing that he's admitting that. But then he's also admitting that they believe it's negligence. So you're right. If this was a civil jury, they would have come to the right decision. But a criminal jury, they don't have enough. And I think the prosecutor's arguments, they argued for negligence, and this jury bought the negligence argument.
Yeah.
We understand. We agree. But you are missing the language where it says or intentional. Related, every single emotion, right, family, others react to guilty verdict in Kim Potter trial. The jurors said the deliberations at times got heated as discussions seemed to go in circles. There was a time during the period where just about every juror cried. But they were respectful of each other, and ultimately, he said they parted on good terms. Juror, it started to all hit us at once, the weight of this. Once we came to final verdict on manslaughter 1, we still had to wait an hour and a half until it was read. So that last hour and a half, I was finally allowing myself to think of the consequences of this tragedy. Obviously we had been thinking about what this meant for Dawn Wright's family, but now I started to think about what this meant for Kim Potter's family. As far as Dawn Wright's family, I just felt a strong sense of loss. And I know there has been this news about accusations that Dawn was not a good person. But that's just not something we were aware of as juror members or thought of.
Nor should you be.
Even now, that doesn't change my opinion on the tragic loss of life that happened. I feel really bad for Dawn's family. It was hard having them on the witness stand. You can tell Dawn meant a lot to them. And it's hard to think about Dawn's son. I think that's the hardest part for me.
And that's
Ragu's. Could you give me your thoughts on
I was going to say, and that's why whenever you are cross-examining the family member of somebody who died, it is always a tricky situation. Earl Grey did a great job. He did
Yeah.
a perfect job of cross-examining Dante's mother. But yeah, it's because you've got a jury that is always going to empathize with the family members of somebody who died, no matter what kind of a person that person was. Somebody died, and that person is grieving their loss. So
Yeah. It's tough.
Hughes? Could you give me your thoughts on how the prosecutors did and how the defense attorneys did? Juror, speaking for myself here, but I think most of the jurors would agree with me on this. I don't think the defense did themselves very many favors. A lot of their antics seemed like purposeful distractions.
Huh.
The prosecution seemed more organized and direct and intentional. The defense seemed like they were throwing everything at us that they could. Everything from, "It was just an honest mistake," to "Don caused his own death." It did not feel very organized
that was
or,
a
for
mistake.
that matter, very compelling.
That's
No, it was a mistake for the defense to say that he caused his own death. That was a mistake because you want them looking at it from that. That's the wrong point of view. It muddles the issues. It muddles what the jury has to figure out and what they don't have to figure out. It messes up your theme. It messes up your story. So that was a mistake they made during close.
Yeah.
Huh.
I also think the defense had great arguments, but I didn't think they had a consistent message and theme where the prosecution's theme was always consistent. And people just like repetition and like to continuously hear things, and it ingrains on you. And I think that's what happened here, where the prosecutors were able to ingrain a particular narrative, and the jurors just went with it, right? So
yeah, no, I mean, narrative is so important because you have so much information that's getting thrown at you as a juror. So when you have a narrative like that, you have a way in which you can actually retain some information, and that hopefully some of it will actually stick to the brain.
And let's not forget, they just, he just said here, it was just an honest mistake, right? They believed that it was just an honest mistake. This juror believed that Kim Potter's mistake was an honest mistake. So they won that argument. They lost on the law. See, they lost on the jurors interpreting the law incorrectly. They won the argument, right? This was an honest mistake. Boom. That's what they were arguing. They were arguing at the whole trial. This was a mistake. They won. But the law, they lost in the interpretation of the law. So
yeah.
And I think is with the appeal. That's why I keep saying the appeal, which is not going to probably be successful. But that's why if they have any shot, it's going to be on the law.
Yeah.
Minneapolis. Edit.
Hey, can we show the article?
Minneapolis.
Yeah,
because you've got us covering it up.
Juror.
There we go. Boop.
Makes it easier to follow.
Back to the article. Boom.
Juror that did come into discussions. The defense seemed like they were throwing everything at us that they, everything from, "It was just an honest mistake," to "Don caused his own death."
We already heard that.
I feel like Kim Potter's testimony and the other officers were the strongest things the defense had. Hughes, what did you make of the defense that Don Wright caused his own death? Juror that did come into discussions and deliberations, but it wasn't a huge focus because we were operating under the assumption that a mistake is not a defense in this case.
Oh boy.
Yeah,
Assumption.
Don's actions, if they weren't taken, we would have never been there. And that just kind of played into the tragedy of it all. And especially when you learned that Kim Potter wouldn't have even pulled Don over in the first place. We did talk about Don's actions, but we as a jury did a really good job of separating his actions from Kim Potter's actions. Don's actions clearly had consequences. So did Kim Potter's. That's kind of the thought process there. Hughes, I know it wasn't your job to think about this and didn't play into your decision, but now that the case is over, what do you think should happen to Kim Potter? Juror, it's hard to say. I hope for a lighter sentence. But when you factor in the vehicle that got hit and also the injury Dawn's passenger sustained, I am of the belief that Kim Potter's responsible for that harm as well, and that should play into her sentence. It just hurts for me to say that because I do think this was a mistake. I also think that does not absolve you from responsibility for your actions. I plan on going to the sentencing for her, and I know it's going to be really hard to sit there. I'm hoping she doesn't get the book thrown at her, but I do think she should get an adequate sentence, especially when you factor in those other factors.
So this is interesting because he's admitting she committed a mistake. He's essentially, he's admitted that. I believe she committed an honest mistake.
And he said, he literally said, we were operating under the assumption that a mistake is not a defense.
Yep.
Woo.
Which is something the prosecution certainly tried to argue a lot. So there's issues with the prosecution's close. I think the prosecution's close is probably the closest you have on appealable issues. Between that and other issues.
Let me run through some of these super chats. They loaded up on me. Joe Chow holds some accountability. Judge Chow's holds some kind of accountability here. Yeah. Should there be ramifications? Her inability to clear up the law led to this miscarriage of justice. This was definitely, I do think this was a miscarriage of justice because she is definitely she's guilty of negligence for sure. No doubt about it. But this whole thing about, let me change our layout so it covers this all up. Probably better. To all those suggesting Kim Potter was a bad and unexperienced cop, 23 years as a patrol officer, no complaints, minimum weapons usage is a good thing. We want police, not soldiers. Her career seemed to embody that. Very true, Peter. Very true, Peter. Yeah. It's funny because in this is one of those few cases where the cop's perfect record played it like Chauvin. They were like, he's a bad cop. He got all these complaints. He's beating people up. And this one is a good cop. She should have known better. They
I tell you what I said before.
You
can't win. You can't win. There is no right answer. There's never a right answer.
Could the argument be made? True liability should be with the severe lack of training by the department, budget cuts due to political atmosphere. Of course, that's going to be. But the thing is, it always comes down to individual action. You're making a more generalized argument. I served in the military for 22 years, trained with firearm 2-3 times a week for 10 years before my first combat experience. My first firefight, my rifle would not fire. Damn, that's tough to find out.
It's a rough time to go.
Off the safety. You didn't take it off the safety. High stress causes mistakes. Yes. And that's what happened here. That's exactly what happened here. You got a cop. Go ahead.
I was going to say, no, I mean, that's a perfect example of the military trains all the time. That's what they are doing all the time. My Andy, he was in what was it called? Field artillery. And I remember I was like, what is that? What exactly do you do when you go to work every day? He's like, we do like field exercises and this and that. I'm like, yeah, but like, what do you do? But that's exactly what they do, is that they train for the possibility that they will get sent into a war zone and they will have to, use their skills that they have learned and been trained on, for however many weeks, months, years. It's crazy to me that cops get so little training, and yet we expect them to essentially be in a war zone every single day. And without a break.
Are you calling America's streets a war zone?
I mean, yes and no, but like every day is a potential firefight for for
No, I'm just giving you shit, right?
Of course.
Yeah.
I know. But it's and those deployments that they go on in the military are 6 months, 9 months, maybe. They used to be a lot longer, but you go to a war zone, you come back home and you cool off. Cops don't have that. They don't necessarily have that. This is a year-round gig for them.
Yeah, it's tough. Can this be brought up? Can this be brought up at sentencing and mitigate anywhere? I don't think you can. I don't think they said it can't even be given to the judge in any way. You can't.
It doesn't
bring
exist.
It up.
They'll
never
do
anything with it. Yeah,
never let it in. You'll never let it in.
The veil
They'll
of the
put
jury,
it in their appeal briefs. The other side will throw a hissy fit. It'll be stricken out.
Even you can't even say it in the courtroom. Like, oh, this is what happened. No, what is he saying? No, it's improper. They can't consider it at all. Those jurors are why I hate normies. Well, you know what?
And there are good jurisprudential reasons, by the way, for this somewhat harsh sounding rule. It's like, because if we allow because we work on a precedential system, right? So it's like, well, why wouldn't you? Well, it's like, well, think about it. Like, if you let those holes in, it suddenly becomes open inquiry for the jury. And maybe you think, well, that's a good thing, but it's like, we've kind of decided it's a bad thing, so we don't want to open those inquiries, because it's like, yeah, no, we don't ask those questions. Just this one time is not a good thing to do in law.
Now, this one is interesting. I don't think the instruction said that mistake was not a defense. I think it didn't have the word mistake is a defense in it, because the prosecution kept saying in the instructions, you will not see the word mistake in the instructions at all. It's not in there. It's not in there. It's not in there. So I'll relook at the instructions, but I don't think it had that language in there. I know the prosecution argued specifically that the word mistake was not in there and it was not a defense. And you can look through the jury instructions, you will not see the word mistake. What does the panel think on whether or not the judge would find those aggravating factors at sentencing? Aggravated factors. What do you guys think?
Hard to say. I think probably not, if I had to guess. I think the lower end, because she's not like she was really abusing her authority. So I don't really find those factors, but I'm kind of sympathetic, so I might be the wrong person to ask.
Yeah.
What aggravating factor could you give with a mistake though? It's like, it's like if the judge is like this with these jurors and wants this whole thing, and she thinks this is a mistake too, then how can you have any aggravating factors?
Yeah, I want to look at the list of aggravating factors that they have in Minnesota, but I think I'm just thinking back on Chauvin. Remember, there was one of them that it happened in front of a minor.
Yeah,
that was an aggravating factor.
Yeah.
But I don't think that's present here, because I think the girlfriend is over 18. You know, this was her first offense, so I can't think of any
Well, the one about the public trust one. Like there's one about acting like under public trust and state authority and something like that. But even that one, I don't really see. Yeah.
I'm hoping she doesn't get the book thrown at her, but I do think she should get an adequate sentence, especially when you factor in those other factors. Related, Kim Potter found the juror said he does not like the notion that their verdict was based on any sort of revenge for past crimes that other Minnesota police may or may not have been responsible for. I think that just kind of cheapens the verdict and the seriousness of this, he said. This was strictly about Don Wright, Kim Potter, and the law. I think you couldn't have asked for a better group of jury members. The fact we didn't concern ourselves with those big picture things really speaks volumes to me and tells me we did a good job. I really think we made the right decision. When asked for any final thoughts, the juror said he and others on the panel wanted to express thanks to the Hennepin County Sheriff's deputies who escorted them to and from the courthouse and shielded them from the public eye. Despite protesters grouping outside at times using a megaphone, he said they couldn't hear it and were not aware of how big or small the demonstrations were.
Well, that's good.
Juror,
that's very good.
We saw no hint of media or protesters or pressure.
That's good.
During that whole process we were treated well and with respect. After it was over, we asked Judge Chu what is the social climate for this case right now? And she compared it to the Chauvin case, saying it was less. Now that I'm free to use the internet, I'm seeing comments suggesting these jurors need to be executed and stuff like that.
Damn,
Oh no,
that's
It's
a little
wild.
much.
The internet is a dark place.
that is true.
But any further final thoughts? I just want to say I wish the best for Don Wright's family. And I wish the best for Kim Potter's family.
Damn, he went to social media. They're like, these
Oh my God,
jurors
maybe
should
he's
be
watching-
executed.
Dude, maybe he's watching the live stream.
For the record, our disagreements do not go to that level. We're also not convinced it's necessarily your fault, because we think the prosecution was full of it and the defense wasn't great.
Yeah.
So, yeah, that's a lot.
Yeah.
Like I went on
I mean,
social media.
No, I mean, and yeah, I mean, I do believe that they probably were looking at this as a very individual, case, that they're like, this is not about Derek Chauvin, this is not about George Floyd, this is not about any of those other things. This is just about the facts that are in front of us and us applying the law to those facts. I do believe that. I do believe that the juries can set those things aside and they can do that. And so when this guy says that, I believe that too. I have no reason to think otherwise, at least. Absent other evidence to the contrary, right? But yeah, I just it's sad. It's unfortunate.
Yeah, you know what? I honestly wish I hadn't read that, because that just confirmed all my fears. My fears were that this juror, that the jury reached a verdict based on negligence. And that's exactly what happened. This jury reached a verdict and convicted her of negligence. And
No, I'm glad though.
It's disheartening a little bit.
It is. But I'm still glad that we that we did go through it, because that it's good to highlight these kind of issues. It's better to know where the fault lines are than to not know where the fault lines are.
This was a grave injustice. We cannot continue to allow prosecutors to continue to bastardize the law. From Binger to Ellison, this BS needs to stop immediately. We cannot allow weak judges to continue to stand idly by while this crap happens. This is unfortunately the system we live at. Prosecutors are politicians, and it's a shame, because our system, I always called the courtroom the Coliseum. That's the Coliseum of today. It's where you lose your money and you can lose your life, right? Back then, before, they used to say, you get your best guy and let them fight it out, and whoever wins, that's who's right. Now we go to courtrooms and we talk it out. But if I don't say the right things, you could lose your life. So it's a shame, but that's just it's the way it is. Hopefully in the future we'll have a different system, but right now this is the best we got. Let's just take a moment to compare the jurors' thought process to all of the echo chambers that exist in society. So this juror obviously got it. Well, I'll ask you, what do you guys think happened with this juror? Do you think this juror just got it wrong? Because I'm under the impression that they just really just like, it was just like, what?
I think that where it mattered most for them to really understand the law, they misunderstood it, unfortunately. And they applied the wrong law to these facts. And that it is disheartening. It's very disheartening. But I'm glad we're going through it, because maybe there'll be some litigators that read these kinds of articles and going into their next trial, and they'll say, like, they'll know where these kinds of issues are in their next jury trial. I don't know. Maybe, hopefully.
Where we learn from the misfortunes of others, as I say. That's exactly how we do this thing, right?
Well, if I'm Earl Grey and the rest of them, I'm like, yo, next time we go through this again, it's not gonna be crazy. I want you guys to hear this. So this is the prosecution's closing. I just looked it up. Shows you how much research I've been doing on this thing, because I had a whole video ready to go about this, and now I'm like, oh, I gotta throw out this whole video. I have to redo this, because now we have the inside information. But here it is. This is what the prosecutor says about mistake.
There's no mistake defense. You will not see an instruction on the defense of mistake. The judge will not give you an instruction that says a person is not guilty if they commit a mistake. That's not the law, no matter how often the defense says mistake.
Huh. Tricky way around it.
So they told the jury straight up.
Yeah.
It doesn't matter. This is what they told the jury. So this is where I think this is where the wiggle room for the appeal does come in, because the jurors really repeating what he just said.
Yeah.
They won the mistake argument.
Yeah.
Right? They won the mistake argument. And to the conscious disregard, here's another clip where they won that one too, where they make the argument that, hey, you know what? We don't have to prove she had a gun in her hand. So it seems like in Minnesota, you don't have to prove any of this stuff. You just got to prove that she had a gun. Essentially, here's the other one about whether she had a gun in her hand.
Mistake is not relevant here. It's not a defense to the charges.
Ooh.
Not have to prove, moreover, that she knew she had a gun in her hand. If the state was required to prove she had a gun in her hand, that she knew that, we would be talking about an intentional crime.
You see what he just did there? He conflated the two. He said that if we had to prove she had a gun in her hand, then we have to prove it's an intentional crime. So in other words, if I prove she had a gun in her hand, I had to prove he intended to shoot him. That's not true. If I prove that they had a gun in the hand and he could drop the gun, or we were saying, remember the twirling around? So when you don't intend to kill anybody, he's just conflated the two. Having the gun means I intended to kill, which is not true. Those are two separate things.
But the question here now is, was there an objection?
Yeah, they objected to it after, like after what's not during the trial, but the motion to dismiss right after. They made these two objections. Okay. So they did preserve them for appeal.
Okay.
So
okay.
So this, unfortunately, the jurors bought the prosecutor's argument.
Yeah,
that's essentially what happened here. They wholesale bought the prosecutor's argument. You don't need to have a gun. It doesn't need to be intentional. Hell, like even mistake. Even if she made a mistake, convict her. And that's exactly what they did.
Ooh.
Yeah. So what do you guys think about the law? Because it seems like they were given the wrong law by the prosecutor.
Yeah.
Yeah.
Does that increase the chances of appeal or not?
Yes. Yeah, I think it was often enough and repeated enough that it forms the basis of a plausible line. I feel good. I feel as good as one can feel going into an appeal, writing those lines of argument.
Which those
it's
are
not that great. I was like, hey, my baseline odds of winning are 2%. So hey, now I'm feeling 4% confident. Whoa, look at that level of confidence. Man, we are almost 1 in 20 chances now. Wow, I'm really thinking it's going well. Yeah, that's about where it's sitting.
Oh boy!
Don't worry.
Yeah.
Lady Ziploc is upset, but don't worry, Lady Ziploc. I'm telling you, she will. There's going to be an appeal, and people are going to be fighting.
At least Ghislaine Maxwell's going to jail. Fuck her.
Yeah. I feel better. Still not good. That the jury made the decision based on the misunderstanding of the law, rather than they were trying to fry her. Yeah. And I'm happy that politics really wasn't involved in it too. Thanks for having Mrs. Bites on. Love her input on things. Plus, she needs validation.
No, these guys are good guys. I love these guys. We're all friends.
And here's one. This is why I believe the fault lies with Judge Cho. She did not clarify the law after the state clearly lied about the law. Yeah, the state. I don't know. The state bastardized this law so much. They were literally arguing negligence and just calling it reckless.
Yeah, I think that's right. That's bad.
The argument, infuriating because this was during the back door. Yeah, this is the back door closing, not a rebuttal. It was, and I don't know. It's at least now we're
talking for a while more. Are we?
No, I'm just going through. I'm just wrapping up.
I don't know where we are because I want to know if I need to get another drink or something.
Oh, you're gonna have that's it. Here we go. Please discuss. All right, so this will be our last question. Please discuss the judge and her indifference making the law clear and correcting the prosecution when it stepped over the line. So why don't you think number one, do you think the judge should have corrected the prosecution saying that mistake? Because obviously we all, when the juror was saying it, you guys said it also. You guys said, well, mistake is not a technical defense to it, but if you find it a mistake, it does kill recklessness, right? It's not it kills one of the elements of recklessness. So do you think the judge like why do you guys think the judge didn't step in and clarify that? Because that seems to be the problem. The reason why the jury convicted is because they weren't clear on that point.
I don't know. Maybe there's something
Yeah.
specifically in state law that binds her in some way on this issue. I don't know.
Or local practices, maybe. I don't know, but it's still not. I don't feel good about it. I don't feel good about the fact that the judge didn't get involved and say, like, "Hey, this is actually not the law." Sorry if you guys can hear my dad in the background.
Oh no! Is that an SM7B? You got Mike. You upgraded on the road too.
No, he's got an
yeah.
She's got the MV7. She's got the
MV7,
USB
yeah.
version, which sounds really good.
Thank you. Thank you.
It sounds really
Can
good
you?
too.
But can you hear my dad in the background?
No,
Okay.
it's good at rejecting noise.
No.
Okay, good.
Yeah.
Because I'm quarantining with my parents. We've all got the coof. So
you got like a full setup there. You got the boom mic and everything. I'm like, you travel well. It's like you got your whole YouTube setup. It's like when I'm on,
yeah.
I'm like, I have this blue mic that
Did
I'm
you pack
holding
the
on.
boom mic?
Like,
did you pack the boom mic?
It's a table. It's a table one. It's it screws onto the table. Yeah, so this is why Mr. Bites was complaining about the fact that my baggage was overweight, but I was like, I've got a whole studio in here. What do you expect?
How are you streaming your video?
I've got my DSLR hooked up to my laptop with an HDMI converter, video capture card.
Oh
man.
So
I got a video capture.
Yeah. And I've got my lighting here. Like I've got everything, dude.
Wow, really?
Wow, you were prepared.
I know it all fits into one a carry-on, like a rollaway carry-on.
Yeah, now I wish I put on my light. I'm just using the ambient light right now.
Yeah, I got a ring light here. I got to put on my other light. Well, listen, let us get out of here because I don't want to keep you guys too long. We've only been here for 2 hours. Damn, it's been crazy. So
only an hour and a half.
Well, yeah, that's true. It's how much? Yeah, an hour and 36 minutes. So, final thoughts on this juror. Was it what we expected? Was it what not we expected? I was kind of surprised at the guilty verdicts, but now listening to with this juror, they were just totally confused on the law, and I understand why they were confused on the law. But what can you do right now? I do feel bad because like a lot of people in the chat are saying, this poor woman's going to go to jail now and have this criminal record, being convicted under the wrong standard. And there really seems to be nothing we can do about it. Is it, it's kind of like, you're helpless with this, but unfortunately we live in it's weird to say. Kim Potter made a mistake to get her in this situation. And then now there was a mistake created to put her in jail. So it's like a mistake compounded upon another mistake. So.
Too many mistakes. Oh man.
What do you guys got coming up? Anything good?
I'm gonna do tomorrow is my latest in the law. I guess New Year's Eve edition or almost New Year's Eve edition. You guys free? You want to join?
Oh no, yeah, I'm really busy at work. I didn't get as much done as I needed to. Probably a lot more alcohol is in the cards for me, and we'll see how it goes.
Alrighty, cool.
Well, listen, thank you guys so much for the super chat. Thank you guys for so much stopping by. We had about almost 3,000 people here watching, so that was fantastic. As we saw the reason why this poor woman was seemingly a miscarriage of justice almost. But we move on to another day. Hopefully the wonderful appeals court will set her free, but we're not really gambling on that. Next, we're moving on to women's soccer because they are going to be giving oral arguments on March 3rd. And thank God again for the Ninth Circuit. I'm a prayer. So
yeah,
thank God for the Ninth Circuit.
Dude, the Ninth Circuit really modernizing here. I like it. Maybe we should be covering more of the Ninth Circuit now that we've got some live streams coming out of there. I think they're asking for it. They're like, hey, Latu.
I mean, they are the biggest circuit in the country, geographically, population, everything. Why not?
Yeah.
And now we're going to be able to see it. And it was like, as soon as I saw it, and I'm like, they're putting stuff on YouTube. Nobody's watching that crap. But when I saw it, I'm like, oh, wow, they put their latest one on YouTube. And you get like 30 minutes oral arguments in front of the three-judge panel. But that's going to be awesome. I want to see what their argument's going to be because it's just so fascinating just to see, like,
Yeah.
and I'm surprised it's even got approved to go to appeal, but we will see. So hopefully you guys will be able to join me March 7th. It's like 2 months away, but we're planning for it now, right? We're planning for it now. Hopefully it'll be a big day.
Absolutely.
So for my guest, I will see you guys later. Don't forget this for Uncivil Law and Legal Bites. Click their names in the title and it'll take you straight to the channel. My name is Nate the Lawyer, and I am out of here.
All right.
Peace.
See you guys.